Hi guys, welcome back to the channel. This is the House of Law and I'm Attorney Al Jumrani. So guess what? We have a new video and this video is different from my previous videos. Several weeks ago, I did a live stream on the topic sales and lease. So if you want to watch that, you can check the link in the description box or maybe you can find it up here. I'm going to put it as a card. Now you can watch that, or if you have already taken sales, this video will help you test if you have in fact understood and comprehended the principles as well as the basics on the law on sales. So what will happen in this video is that I will be asking questions and give you time to answer. You can submit the answer. No, just kidding. Of course, I will give you time to analyze the question and then that's the time I will show you the answers. All right, so let's do this. So the first question is, Irma and Brian are buying a house. If the house burns down after they sign the purchase agreement, but before the house is turned over to them, who takes the loss? What do you think? Is it Irma and Brian or the seller? Let's see the answer. The seller is liable for the loss because the seller is still the owner. The principle of res perit domino applies. The thing perishes with the owner. In the law on sales, the ownership of the thing is transferred to the buyer after delivery. Here, the house was not yet delivered. Hence, the seller is still liable. Next question. June found an antique lamp at a bargain price at a garage sale. She gave the seller a check for the lamp and told him she'll pick up the lamp later. The seller agreed to keep the lamp until June returned. However, a few hours later, the seller sold the lamp to someone who offered more money. Is the sale to the second buyer valid? Okay. A previous sale, the thing was not taken by the first buyer. The seller sold it the second time to a different buyer. So is the second sale valid? What do you think? All right, let's check the answer. The sale to the second buyer is void due to lack of a valid object. Under the law on sales, the object of the sale must be one the seller of which has title to transfer to the buyer. In this case, the lamp had already been sold to June and constructively delivered when the seller agreed to keep it until June returned. Thus, the seller had lost title or ownership of the thing and could not legally sell it to another person. Okay. In my live stream, I discussed the principle of nemo dat quod non habet. You cannot give what you do not have. So that principle applies here. The seller could not have sold it the second time because he had already sold it the first time and the thing was already constructively delivered. All right, that's the second question. Now let's look at the third question. Rosemary gave Elaine 500 pesos so that Elaine would not sell her camera to anyone else until Saturday. When Saturday came, Rosemary told Elaine that she changed her mind and wanted the 500 pesos back. Elaine refused to return the money. Is Elaine correct? Rosemary gave Elaine 500 pesos so that Elaine would not sell her camera to someone else. That reservation, or should you say the holding of the thing, would be until Saturday, but then when Saturday came, Rosemary changed her mind and wanted to get back the 500 pesos. But Elaine doesn't want to return the money, so is Elaine correct? Let's check the answer. Yes, Elaine is correct. What the parties entered was an option to buy. Rosemary was given the option to buy the camera until Saturday. To be valid, an option must be supported by a separate and distinct consideration. In this case, the separate and distinct consideration was 500 pesos. It was intended for Elaine not to sell the camera to anyone else. Since the option expired on Saturday and Elaine complied with her obligation not to sell the camera to anyone else, then Rosemary could no longer ask for its return. So were you able to get the answer? clearly we are talking about options. So options is as important as earnest money and other topics in sales. All right, so let's check the next question. Loretta bought a car through a car loan with a bank. Later, due to several unpaid installments, the bank foreclosed the chattel mortgage on the car and acquired it during the auction sale. One day, Loretta received a letter from the bank demanding the payment of the unpaid installments. Is Loretta still bound to pay the unpaid installments? Okay, try to understand the question. Loretta obtained a car through a car loan, but it was unpaid. She defaulted, so the bank foreclosed the chattel mortgage, acquired it during the public auction, but then the bank wants to collect or recover the unpaid installments. So is Loretta still bound to pay those unpaid installments? Let's check the answer. No, Loretta is no longer bound to pay the unpaid installments. Under Article 1484 of the Civil Code, on sale of personal property on installment, the unpaid seller has alternative remedies. He can either seek fulfillment, cancel the contract, or foreclose the chattel mortgage if one was constituted. These remedies are exclusive and alternative. When one remedy is availed, the others are no longer available. In this case, the seller opted to foreclose the chattel mortgage. He can no longer recover the unpaid installments because that would amount to availing another remedy, which is fulfillment or specific performance. Okay, so I hope you got that correctly. Well, it's good to take down notes. So far, we have a question on options. We also have now a question on direct to law, which is Article 1484 of the Civil Code. All right, let's check the next question and see what principle is applicable or is being asked. Okay, question. Duncan bought a floor carpet on credit with installation included. However, the installers did a bad job. Duncan wrote the seller to rescind the contract because the job was not done properly. Was this a sale or a contract for a piece of work? Is rescission proper? Okay, try to read again the question, understand the facts, and identify the issue. So is it a sale or a contract for a piece of work? And if you answer either, is rescission proper? All right, let's check the answer. It was a contract of sale. That the seller offered installation service did not change the nature of the contract. A contract for a piece of work is one that involves the production of a thing specifically for a certain customer. This was not the case here. Thus, the poor installation did not go into the main prestation of the contract, which was to sell to Duncan the carpet. Rescission is not proper, but the installation could be redone at the expense of the seller. All right, so I hope you got that answer. Okay, so here we have the difference between a contract of sale and a contract for a piece of work. Okay, next question. If a store displays a specific item in its window at a discounted price, is it required to sell the item at that price? We always see this. We go to the malls and then we find item being displayed, or maybe the prices, the discounted prices being displayed, and we get interested, and then we get the item and we pay for the item. But is the store bound to sell to you the discounted price as displayed on the window of the store? Let's check the answer. Yes, the displayed discounted price is a public and continuing offer by the store. If a customer enters the store and takes the item, that means that the customer has accepted the offer, thus resulting in a perfected contract of sale. All right, so simply the principle applied here is the perfection of a contract, and the perfection of a contract of sale is the meeting of the minds over the object and over the price. Okay, next question. A mail order catalog offered ladies' apparel and cosmetics at discounted prices. The discounted prices would expire on July 30. Julia mailed her order on July 30 and it was received by the seller on August 2. On August 3, the seller wrote Julia telling her that the discounted prices were no longer applicable and that she had to pay the regular prices. Is the seller correct? The situation is quite familiar. I'm sure a lot of you must have encountered problems with discounted prices not being honored because supposedly the discounted prices were only valid up to a certain time. And so, is the seller correct in not honoring the discounted prices and asking you to pay the regular prices? All right, let's check the answer. Yes, the seller is correct. Under the law on sales, the contract is perfected upon the concurrence of the offer and acceptance. But for such concurrence to happen, the offerer must have actual knowledge of the acceptance by the offeree. In this case, the seller knew of the acceptance by the buyer of the discounted prices only after the expiration of said discounted prices. Thus, there is no binding contract with respect to the discounted prices. Okay, remember, when two persons transact and they are from different places and the offer is either mailed or transmitted through other means, the contract becomes perfected upon the actual knowledge or notice to the offerer of the acceptance by the offeree. So in this case, there was no binding contract when the buyer sent back the order form, but rather the contract was perfected upon acceptance or upon receipt by the seller of the order form, okay, from the buyer. All right. Okay, next question. You ordered a set of Chinaware from Shopee during the 4/4 online sale. However, the Chinaware arrived with several pieces broken. Is Shopee liable? Well, I hope this never happens to me. I'm quite fond of online sales now recently because we are actually stuck at home, and so we just browse through Shopee and Lazada and we just add to cart and check them out. Okay, but yeah, this is the question. So the ordered goods arrived broken and damaged. So is Shopee liable? What do you think? All right, let's check the answer. No. Like Amazon and Lazada, Shopee is an e-commerce platform where sellers and buyers meet and do business. The party liable for the damaged goods is the seller. The seller would be in the best position to determine if the goods were sent in damaged condition or if they were damaged in the course of the shipment. All right, so did you get the answer? Well, we usually think of Shopee as the seller, but no, Shopee is not the seller. And in fact, in the United States, a court has already ruled that Amazon is not liable for damaged goods because Amazon is only a platform and not the seller per se. But of course, under best practices, these e-commerce platforms should provide the remedies or the mechanisms for the buyers to get a refund or to file complaints against the sellers and against the goods sold by sellers. All right, next question. Jay bought a subdivision house on installment payable in 5 years. The developer assigned its rights under the contract to sell to the financing company. Jay defaulted on his payments. The developer demanded that Jay continue making his payments or it will file an ejectment case. Is the developer correct? Well, that usually happens, when you buy a house or when you buy even a condominium unit, the developer, the project owner, sells or assigns its interests as well as its rights under the contract to the bank. And the bank now assumes the role of the seller in that contract and thus has a right to collect the balance of the purchase price. So How about this question? Is the developer entitled to demand payment and threaten J with ejectment for J's failure to update his payments? Okay, let's check the answer. No, the developer is not correct. In Spouses Noinai versus City Homes, this case was also discussed in my live stream, so you might want to check that out. It was held that the assignment by the developer of its rights and obligations under the contract to sell to a bank makes the former a stranger to the contract and deprives it of a cause of action to eject a buyer who is now a borrower of the bank. Right. Okay. Next question. Luna bought a car from Honda. The agreement stated that the full purchase price shall be paid upon pickup on June 17, 2020. There was no mention of the manner of payment. Is the contract valid? What do you think? A very simple situation, but is it valid? All right, let's check the answer. Yes, the contract is valid. All the elements of a contract of sale are present, although it is also required that the parties must agree on the manner of payment. There is no required form or stipulation. In this case, the manner of payment here is that agreed upon, which is full payment upon pickup of the unit on June 17, 2020. All right. Okay, next question. Marcos paid Roma Glass and Aluminum to fabricate, furnish, and install for him an indoor aquarium similar to what was in the store website. After completing the work, Roma Glass and Aluminum billed Marcos. But Marcos refused to pay because the actual aquarium was ugly and did not look like what he saw on the website. Is Marcos correct not to pay? Dahil pangit, ayaw na magbayad? I mean, put yourself in the shoes of Marcos. Is Marcos correct in not paying Roma Glass and Aluminum because the aquarium that was installed was far from what Marcos desired or wanted based on the aquarium that was shown on the website of Roma Glass and Aluminum? What do you think? Okay, let's check the answer. Yes, Marcos has a right to refuse payment. The contract is a sale by a sample, as Marcos made reference to a sample, that is, the aquarium shown on the website of Roma Glass and Aluminum. In a sale by sample, there is an implied condition that the thing shall correspond with the sample in quality. In this case, Roma Glass and Aluminum failed to make the aquarium conform to the sample desired by Marcos. Okay, so try to brush up on your stock knowledge about sale by sample as well as sale by description. All right, let's check the next question. If X buys a car from Y and X issues a check, which when presented for payment is dishonored, is the contract void? Ayan, sa mga mahilig magbayad ng mga utang nila or mga purchases through a check. So what if the check is dishonored? Does that render the contract void? What do you think? Let's check the answer. No, the contract is not void. The dishonor of the check given as payment only resulted in failure of consideration. What makes a contract of sale void is the lack of consideration, which is the total absence of an agreement over the price. When there is a failure of consideration, the contract is still valid, but the seller has the remedy of either demanding payment or rescinding the contract. All right, so review on the difference between failure of consideration and lack of consideration. Okay, next question. Isagani ordered through telephone a number of law books from Rex Bookstore. The condition was cash on delivery. When the delivery guy arrived with the books, he demanded payment from Isagani, but Isagani did not pay. Instead, he grabbed the books and ran. Isagani then sold the books to his classmates. If Rex Bookstore is able to track down Isagani's classmates, may Rex Bookstore take back the books? Okay, Read again the question. Try to understand what happened and what's the issue. The issue is, may Rex Bookstore recover those books? All right, let's check the answer. Yes, Rex Bookstore can recover the books from Isagani's classmates because Rex is an owner who was unlawfully deprived of its personal property or movables. Under Article 559 of the Civil Code, one who has lost any movable or has been unlawfully deprived thereof may recover it from the person in possession of the same. Here, Isagani seized the books and sold them to his classmates. His classmates had no better right than Isagani. Okay, you might want to read on Article 559 and relate that to the law on sales. All right. Okay, let's check the next question. In 2018, Erica purchased on installment a condominium unit in Makati City. She paid from June 2018 until July 2020. Because of the COVID-19 pandemic, she lost her job and could not continue the installment payments. Is the sale covered by the Maceda Law? What are Erica's rights, whether under Maceda Law or otherwise? A very real situation, a real problem. Now, this COVID pandemic has made a lot of loans unpaid, a lot of installment purchases discontinued. Yeah, so what do you think, guys? Okay, what are the rights of Erica under Maceda Law or other laws? All right, let's check the answer. First, under the two Bayanihan Acts which were passed by Congress in response to the COVID-19 pandemic, Erica was entitled to a deferment of her amortizations for up to 60 days. Secondly, assuming that she could no longer continue the payment and it appearing that she has paid for more than 2 years, she is entitled to a grace period, a cash surrender value, and notarial notice of cancellation as provided under the Maceda Law. All right, so since this is the law on sales, the Maceda Law is an integral part of this subject. And if you're reviewing for the bar or just your exams in your sales class, never miss the Maceda Law. All right, so that's the last of it, guys. So if you have some, vague understanding or vague questions or topics that you want us discussed, please comment them down below, and maybe we can make a video about these problem areas in the law on sales. All right, thank you very much for watching. If you like this video, please drop a like. If you haven't subscribed to my channel yet, please subscribe to show your support, and please click that notification bell so that you will be notified in case I upload a new video, which is usually like 2 or 3 days in between. So I'll see you in my next video. Laging tatandaan, isip ay buksan, alamin ang batas.